Welcome to NASET's webinar. If you're new to NASET, our members enjoy free access to webinars like this one, along with exclusive resources, expert-led sessions, and discounts on continuing education programs. Legal Services in New York City is one of the nation's largest civil legal services organizations dedicated to fighting poverty and advancing racial, social, and economic justice for low-income New Yorkers.
All of our services are free for low-income residents. We are part of the Legal Services Corporation, which funds approximately 130 different nonprofit legal services organizations in every state, U.S. territory, and Washington, D.C. when they are communicating with schools. We are attorneys in the Education Rights Project at Legal Services NYC. We work with families to advocate for students with disabilities. We also represent students in their exclusionary removals. We do some policy work around improving school climate. We also do non-legal advocacy around getting school transfers, school transportation, as well as charter school issues. We have worked really extensively to make sure that language access is provided to parents when they are communicating with schools.
I think we all are familiar with the Education for All Handicapped Children's Act. That was the original law that brought special education services to states throughout the country. This law was passed by Congress in 1975. What many of us may not know is that that original law did not actually contain the manifestation determination review provisions. Many understood that those stay put and pendency provisions actually prohibited school districts from long-term suspensions or expulsions for students with special needs. Part of the reason why the law was passed, there was a huge movement to try to correct and address serious problems that students with disabilities were experiencing, and oftentimes school districts were using the discipline process to achieve that. However, by the 1980s, there was the start of sort of a rebalancing of those discipline due process rights. The United States Education Department, through the Office of Civil Rights, they adopted a position that suspending a student for the first 10 school days was permissible. That didn't result in actual change in placement. And the Supreme Court essentially saying that there wasn't a way for school districts to find an exception to the stay put provisions by saying that a child was dangerous. But they did uphold that position that the United States Education Department had come up with, that students could be excluded for the first 10 school days. In the 1990s, we saw Congress rename the law. They renamed it to the Individuals with Disabilities Education Act. By 1997, they added amendments that further eroded the disciplinary due process rights of students with disabilities. As part of the 1997 amendments, Congress created the actual manifestation determination review process, and they also created this new section of the IDEA where children with disabilities could be placed in an alternative educational setting. In the 2000s, it gave even more authority to school districts to remove children, and they created the Interim Alternative Educational Setting, IAES, where school districts can actually remove a student with a disability for up to 45 school days. School districts can accomplish that by either seeking a hearing officer to order a student be placed in an IAES, or the district can unilaterally do it on its own if the student had engaged in certain types of conduct. The law specifically gives school districts the ability to remove a student with a disability to an interim alternative education setting if the child engaged in conduct that involved possession or use of a weapon or drugs, or they were inflicting serious bodily injury on someone else in the school community. Just important to note that this conduct had to occur either on school premises or at a school-related function. The law defines this as substantial risk of death or extreme physical pain.
an incident has happened and you're having to think through, is a school removal appropriate? And why are schools often looking towards use of suspension or expulsion, right? It often boils down to trying to teach the student consequences in hopes of doing kind of one of three things. One, deterring that future action, two, trying to teach accountability, right, and build that within the student, and three, trying to secure safety within the school community. Use of suspension, particularly long-term suspensions, doesn't always lead to these outcomes that we would want, right? It doesn't actually deter behavior in certain cases, but can instead exacerbate them. Studies have shown that it can lead to disengagement from the community and disconnectedness, and that can lead to things, right, like dropout or dropping of grades. It can also lead to increases of behavior, right? And it also found that there wasn't connections to that improved school climate that was intended. Now going to talk about what MDRs could be. So first we have to start about what happens when school staff are not supported in knowing what is needed in a meaningful MDR. Instead, what results is a loss of opportunity to have a full discussion of what that student instead could need. Instead, turning this MDR into a turning point where we can talk about what are evaluations or meaningful services that we need in order to help that student not engage in that behavior moving forward. So these are graphs that were created by the Office of Civil Rights at the Department of Education. And so what it showed was in 2017 to 2018 school year, students with disabilities made about 16% of students in the general population of students in schools. But then when we look to those surveying suspensions, they made around 25% of those who faced in-school suspension or expulsion and around 28% of those facing out-of-school suspension. So what that means is students with disability missed over 3 million days of school. This indicates to us that part of this is also a issue of how are we doing MDRs meaningfully and using them as a turning point for the student. The importance of MDRs, again, is thinking about our historical context, how we continue to see students being excluded disproportionately, what can happen when we fail to appropriately serve students to help them in building the skills to reduce behaviors moving forward. And that, lastly, what I haven't touched upon is when MDRs aren't done properly, when it instead feels to a family that something has been done improperly and hasn't been followed by the law, that can instead just further mistrust between the student and the school system and their families. So having a meaningful and appropriately followed legal procedure for MDRs both serves the school and families. So when MDRs are done properly, it can mean a meaningful discussion between families and school staff about the context and the cause of that behavior, the why that we need to get to. It can allow for a more meaningful discussion of reviewing the breadth of this student. So not just thinking about this one incident, but what has been the overall course of this year, prior years, and seeing a pattern and seeing if we really need more evaluations to understand this student. And it can also be a moment to prompt discussion of what services and support would be helpful to build for that student. And when we can have these meaningful discussions and where families can feel heard with staff listening to them and staff can speak and families can also learn more about their child at school, it really helps to form that relationship and can improve it. Sometimes can be more difficult than that, but it's an opportunity to have a meaningful discussion that can build rapport.